Hi, everyone. We're just going to give it a couple of minutes to allow everybody to arrive to our virtual town hall. Hi, everyone. I'm just going to give it one more minute and then we'll begin. Hey, well, hi, everyone, and welcome to ACTRA National's first virtual town hall on the Online Streaming Act and you. I am Eleanor Noble, president of ACTRA National. I'll just start off by running through a few things before we get going. If you have any questions during the meeting, please use the Q&A feature in the Zoom. We will complete the presentations and then address your questions. And when speakers reference websites or resources for members, we will make those available to all of you. And for those of you who require captions, please click on the auto caption button at the bottom of the screen to turn it on. Just to let you know, we are recording this session and we will make the link available to all of our members. All right, so welcome once again to all of you who've joined us today. We will begin the session as we do all our meetings and gatherings with ACTRA National's Land Acknowledgement and Equality Statement. I'd like to introduce Gagan Singh, ACTRA Toronto Councillor and Treasurer. Gagan? And if you started reading, we can't hear you because you may be on mute.
Here I am. Now I'm finally on. Even we at council have issues with technology. So here we go. Hello, friends. Now, although this meeting, this town hall is online, we acknowledge that we live and meet and work and travel on the traditional territories of Indigenous peoples that have cared for this land, now called Canada, since time immemorial. These lands are either subject to First Nations self-government under modern treaty, unceded and unsurrendered territories, or traditional territories from which First Nations, Métis, and Inuit have been displaced. To highlight the importance of this acknowledgement, I urge you to take a look at the map from the Native Land Digital website and search the territory on which you are located. We recognize that we are all treaty people and seek to work towards redressing the injustices from which we have benefited.
Thanks very much, Gagan. And now I'd like to introduce Teresa Tova, Treasurer of ACTRA National and past President of ACTRA Toronto.
Thank you, Madam President. The ACTRA Equality Statement. Union solidarity is based on the principle that all union members are equal. Mutual respect, cooperation, and understanding are our goals. We embrace an open and inclusive environment and encourage respectful behavior that affirms the dignity of all individuals. We neither condone nor tolerate behavior that undermines the dignity or self-esteem of any individual or creates an intimidating, hostile, or offensive environment. Discriminatory speech or conduct based on gender, gender identity, sexual orientation, race, disability, age, class, language, religion, ethnic origin, membership, region or work category, or family status hurts and divides us. Discrimination can take the form of harassment, defined as using real or perceived power to abuse, devalue, or humiliate. Discrimination and harassment weaken our solidarity, reducing our capacity to work together on shared concerns such as decent wages, safe working conditions, and justice for all. ACTRA activities are to be harassment-free zones where our members' dignity and equality are respected. ACTRA's constitution, bylaws, practices, and collective agreements reflect our commitment to equality and respect. Complaints of harassment and discrimination are taken seriously by ACTRA and should be directed to the president or their designate. All will be investigated, and those substantiated will result in action by the union. Thank you.
Great. Thank you very much, Teresa.
Yes.
We are elated to have all of you join us today for what will be an informative town hall on the proposed Online Streaming Act, previously known as Bill C-10, now going through a second reading in the House of Commons and renamed Bill C-11. This proposed legislation will have a substantial effect on our industry, your jobs, and Canadian culture. ACTRA National has been advocating for years for a modernized broadcasting system that brings online streaming services under similar rules and requirements as traditional broadcasters. We hope now is the time this important bill will finally be passed. The purpose of today is to share just how Bill C-11 would impact ACTRA members and our industry. I'm pleased to welcome and introduce to you our panel. From the Canadian Heritage Broadcasting Senior Director, Marketplace and Legislative Policy Broadcasting, Copyright and Creative Marketplace Branch, Amy Awad. Director, welcome Amy. Director General of the Broadcasting, Copyright and Creative Marketplace Branch at Canadian Heritage, Michelle Saba, was due to join us today, but unfortunately cannot be with us today because due to unforeseen circumstances. And finally, I'd like to introduce from ACTRA National General Counsel, Raj Shone. Hi, Raj. Thanks for being here. I remind you once again, if you have questions during the meeting, during this town hall, please use the Q&A feature in the Zoom, and we will address as many questions as possible after the presentation. All right, so let's begin. Thank you for taking the time to be with us today, Amy. I'm going to hand things over to you to give us an overview of the Online Streaming Act.
Well, thank you very much, Eleanor. It really is a pleasure to be here. I'm going to be sharing a couple of slides to kind of walk us through the technical aspects of this new bill. I'll just give it a second for them to appear on the screen. I'd also like to take the opportunity to acknowledge that I am one of those people that is joining you today from the unceded territory of the Algonquin Anishinaabe Nation, on which the National Capital Region is located. And it really is my pleasure to walk you through the government's proposed amendments to the Broadcasting Act via the Online Streaming Act, or Bill C-11. Moving to slide number 3. Of course, I don't need to tell you, but music and television are powerful mediums. Canada has a long history of supporting its music, television, and digital media programming. The Canadian Radio, Television, and Telecommunications Commission, or CRTC, is the expert arm's length regulator of the broadcasting and telecommunications sector. The CRTC requires broadcasters to financially support the creation of Canadian programs and ensures that these programs are widely accessible and available to Canadians. Broadcasting plays a key role in supporting Canada's creative industries and evolving cultural identity. The Canadian broadcasting and creative industries are, as you know, important economic drivers, contributing about $14 billion to Canada's GDP and over 126,000 jobs in 2019. The Online Streaming Act will build on the economic and social benefits that broadcasting already provides. Moving to slide 4. In the past 10 years, subscribers to online broadcasters have grown from 6% to 78% of Canadians. As Canadians have spent more time than ever at home during the COVID-19 pandemic, the migration to online services has only accelerated. The revenues of online video services have experienced fast and substantial growth, with a compound annual growth rate of 20.9% in the past 2 years. Over the same period, traditional broadcasters have seen steadily shrinking revenues, with a negative compound annual growth rate of 4%. This shift in market position demonstrates the urgent need to modernize the Broadcasting Act for our creators, cultural industries, and for all Canadians. Moving to slide 5. The support system for Canadian stories and music is at risk. Online broadcasters are not required to support Canadian music and storytelling or any other important broadcasting objectives. And so, as the revenues of traditional radio and television broadcasters stagnate and decline, so too will the level of support for Canadian music and stories, and for the creative professions behind them. If unaddressed, the current situation presents major concerns. In particular, it perpetuates a regulatory imbalance, which means that traditional Canadian broadcasters are at a competitive disadvantage compared to online. To address this regulatory imbalance, online streaming services must be made to contribute their fair share to supporting Canadian music and stories, including in French. Moving to slide 6. Modernizing the legislative and regulatory framework is both a necessity and a priority for the government. It has committed to this work, and it's clear in a clear way through the 2021 speech from the throne and in the mandate letter to the Minister of Canadian Heritage. The new bill is substantially the same as the previous bill, as adopted by the House of Commons in June 2021, except for targeted amendments to recalibrate the approach to social media and to improve the overall drafting of the bill. And that brings us to the key objectives. The updated legislation or updated bill builds on the consensus reached during the last parliamentary session, while also responding to feedback received. Overall, the key priorities and themes of the bill remain the same. At a high level, the Online Streaming Act sets out to do 5 things. We're going to walk you through each one of those in greater detail. Moving to slide 7. The proposed legislation maintains a new category of broadcasting undertaking, an online broadcasting undertaking. The bill clarifies that the online broadcasters operating in whole or in part in Canada fall within the scope of the legislation. Online broadcasters will not be licensed, which is something that I'm going to discuss in a few minutes, but rather they will be subject to conditions of service, the requirements that broadcasters must adhere to in order to operate in the Canadian market. Users of social media platforms are explicitly excluded from the Act, as well as the programs posted by these users, unless specifically identified by the CRTC. Also something that I'm going to discuss in a couple of minutes. Moving now to the policy objectives. The goal was to modify the policy objectives of the Act so that they are more inclusive for all Canadians. For Indigenous peoples, programming reflecting Indigenous cultures, as well as programming in Indigenous languages, should be available in the broadcasting system, regardless of resource availability. There should also be space for broadcasting undertakings owned and controlled by Indigenous persons. Regarding accessibility, programming must be accessible to persons with disabilities, again, regardless of resource availability. And lastly, the broadcasting system should serve the needs and interests of all Canadians, including Canadians from official language minority communities, racialized communities, and Canadians of diverse ethnocultural backgrounds, socioeconomic status, abilities and disabilities, sexual orientations, gender identities and expressions, and ages. Moving to slide 9. The third major objective, the legislation will shift away from issuing broadcasting licenses to a new conditions of service model that would allow the CRTC to seek contributions from broadcasters and to impose other conditions, including conditions related to the discoverability and showcasing of programs. The CRTC will be given express powers to require broadcasting undertakings, including online undertakings, to make financial contributions to support Canadian music, stories, creators, and producers. The CRTC can also direct contributions to support public interest participation in CRTC proceedings. The CRTC will not be able to dictate the specific algorithm or code that a broadcasting undertaking must use to comply with conditions related to discoverability and showcasing. One of the primary goals of the renewed approach to regulation is to provide sustainable support for Canadian music and stories in the years ahead. Moving to enforcement. To ensure compliance, the CRTC is being provided with new tools, including the ability to impose administrative monetary penalties, or AMPs. Certain government oversight mechanisms of CRTC decision-making are also being updated. The bill introduces a more streamlined and transparent process for the government to issue policy directions to the CRTC. It also updates the process for petitioning the Governor and Council to review CRTC licensing decisions. Finally, the CRTC will be equipped with more effective powers to gather information from industry players and the ability to share this information with the Minister of Canadian Heritage, the Chief Statistician, and the Commissioner of Competition. Moving now to social media. In the last parliamentary session, there was vigorous debate about the role of social media services in supporting Canadian artists and culture. The bill aims for fair treatment of programs consumed on different platforms, regardless of how they are transmitted. With respect to user-uploaded programs, the Online Streaming Act would provide guidance to the CRTC on how to focus on only commercial programs on social media services. To be extra clear, users will never be considered broadcasters, which means that conditions of service and regulations will not apply to individual users of social media. Programs that do not generate revenue will not be subject to regulation. The CRTC will be referring to specific criteria in making its determination as to whether a program will be subject to regulation, and we've included some of those criteria for you. Where a program meets the CRTC's criteria, it would be subject to applicable conditions of service and regulations, all of which must be applied and construed by the CRTC in a manner which is respectful of the freedom of expression enjoyed by users of social media services. Moving to slide 12. This slide gives you a sense of what lays ahead. Upon royal assent, the CRTC will be required to implement the amendments from the updated legislation. The CRTC's implementation decision will be evidence-based and informed by consultation with relevant parties and stakeholders, including creators, producers, Canadian and foreign broadcasters, and the Canadian public. To supplement amendments to the Act, the Minister of Canadian Heritage intends to ask the Governor and Council to issue a policy direction to the CRTC to provide guidance regarding how new broadcasting policy objectives and the CRTC's use of its new regulatory tools. This too will be subject to public consultation with interested parties. It's important that meaningful changes in the broadcasting sector occur quickly. For that reason, the CRTC will be asked to implement new rules in a timely fashion following the bill's passage. And then finally on slide 13. In conclusion, the Online Streaming Act would ensure that we have a broadcasting system that is fair and sustains Canadian music and storytelling into the future. It will make the system more accessible as well as more inclusive by supporting creators and producers that have been marginalized. Building on the foundation of the last 30 years, this bill provides a much needed update to Canada's Broadcasting Act.
Great.
And
No, carry on, Amy. Go ahead.
No, that was it. I was just going to say that's the presentation. I look forward to addressing some questions later on.
Great. I'm sure we're getting questions in now, so we will get to those at the end. Again, everybody, please, if you have questions, put them in the Q&A and we will address them after all the presentations. Thank you so much. Thanks so much, Amy. That was a great presentation. Now to take a look at how the Act will benefit performers and strengthen Canada's broadcasting system, I'll hand things over to Raj Sean, our ACTRA National General Counsel.
Thank you, Madam President. Hello, everyone. Just give me a moment to share my screen. Great. Wonderful. It's good to see everyone. I'm excited to be discussing the Online Streaming Act with you today. This legislation represents a bright new future for the Canadian content industry, performers, producers, and distributors alike. So at a high level today, I'd like to discuss two aspects of the bill with you: why Bill C-11 matters to our industry and how it will impact you as a performer. So why does the Online Streaming Act matter? Our friends from Heritage Canada just touched upon this a little, but I think it's important to fundamentally understand what has happened in our industry over the past 30 years when the Broadcasting Act was last amended. So 30 years ago, we had a broadcasting industry that was as strong as it's ever been. Domestic broadcasters were strong, they were financially healthy, and they were competitive. They actively commissioned Canadian programming in a variety of genres, including drama and comedy shows. Opportunities for our members were plentiful, and there was this thing called the internet, which is basically a rumor to most people. We fast forward to today, and we're seeing a completely different landscape. The broadcasting industry is in decline. You just heard some of the figures from Amy, with over-the-air broadcasters in particular on life support. Industry consolidation has meant fewer players commissioning less content, meaning fewer opportunities for our members. In order to meet their Canadian content obligations, broadcasters have invested less and less funding in the most culturally significant type of programming, drama, comedy, documentaries, and shifted to news, reality, and sports programming, which doesn't employ our members. Foreign streamers have entered the Canadian market, increasing competition while contributing next to nothing to the overall Canadian ecosystem. And in the face of these new challenges, our national regulator, the CRTC, has done essentially nothing to support the domestic broadcasting industry, which is, of course, the primary funder of Canadian content in the country. So it paints a bit of a dark picture for the future, which is why ACTRA and many others have been pushing the Government of Canada for years to take meaningful action. And I'm happy to say, thankfully, this government has taken action. And this bill, the Online Streaming Act, represents a potentially game-changing transformation for the future of Canadian content creation in this country. It also represents a renewal of opportunity for artists and performers in terms of jobs and exposure. The Government of Canada has estimated that the equivalent of over $800 million will be reallocated from foreign streamers back into the Canadian content industry. Now, this will occur as the CRTC extends programming obligations to online streamers and or redirects a percentage of a streamer's annual Canadian revenues back into content development. Now, I recognize that's a little into the weeds, but these are typically the tools employed by the CRTC when it puts obligations on entities. And in a minute, I'll get into what that may look like for you as a performer. The government has also stressed that the CRTC will be focused on ensuring the discoverability of Canadian content so that Canadians are aware that this new content exists and can easily find it in all of these platforms. This act is about ensuring pride of place for Canadian content, and all of you, hopefully, will play a big part in that. So how will it impact you? Well, essentially, the CRTC, through new order-making powers, will require certain online streamers, essentially those that are in the business of commissioning and creating content, to begin investing in a certain amount of Canadian programming. That will include the Netflixes, the Disney Pluses, the Amazon Primes of the world. Of course, what that amount will be is still to be determined by the CRTC in proceedings which will be held after the bill passes. This new programming will be made under Canadian content rules, which require a significant amount of Canadian representation, both on screen and behind the cameras. That means new opportunities for all of you on some of the biggest platforms in the world. In that same vein, ACTRA is confident that online streamers will take every opportunity to leverage this new content in every market in which they operate, meaning as a Canadian performer on one of these shows, you could potentially receive more exposure in more markets than you ever had before. We're optimistic and we're hopeful that this new programming could be the big break many of you have sought in your careers. By the same token, for those streamers who are not in the business of commissioning and creating content, but still play a prominent role in programming distribution, looking at you, YouTube, ACTRA expects the CRTC will require these entities to contribute a portion of their annual Canadian revenues back into the system by way of production funds. These production funds, such as the Canada Media Fund or the Independent Production Fund, there's many of them out there, have been traditionally accessible by Canadian broadcasters and producers to create new Canadian programming, and we expect they'll continue to be so. Again, this programming will prioritize Canadians both in front of and behind the camera, providing each of you with new opportunities in the traditional system, as well as the online world. Oh, pardon me. So, how can you support this legislation? Well, our president has some ideas to share on that front. Back to you, Eleanor.
Great. Thanks so much, Raj. Thanks for all that information, and thanks for helping us break down how important this legislation will be for Canadian performers and our industry. Now comes the important part where you can get involved to help us push this legislation through. As ACTRA members, you play an important role in all this. This bill needs our support to pass through the House of Commons and eventually the Senate. You may be asking, what can I do? Well, ACTRA National wants to help you, and that's why we are having this town hall. Your voice matters and needs to be heard in Ottawa and in your riding. ACTRA National would like to encourage you to consider participating in some of the following ways. We're currently building a take action section on the national website, our actra.ca website, which will have resources and tools for you to use. For example, we may ask you to write or call your member of parliament, your MP, and let them know that as a Canadian performer, you support the legislation. It's very simple. We'll provide a sample email for you to send to your MP. All you have to do is type your postal code into the online form, the MP's name, and then an email will automatically be inserted into the email template. See, simple. The letter's already written for you. Another option would be to reach out and speak to your MP. ACTRA National has online tools to make it easy to connect with your MP. We'll provide you with a sample script, so key points are there for you to highlight and speak on. Hearing directly from our membership is a very, very powerful tool. It's hands-on, which is why your role is so crucial in helping getting this legislation passed. Our previous national president, David Sparrow, worked diligently on trying to modernize our Broadcasting Act, and I'm continuing his hard work to make sure it goes through. ACTRA National is also working closely with our industry partners, who include the Directors Guild, the Writers Guild, Union des Artistes, UDA, Canadian Media Producers Association, the CMPA, and the Coalition for the Diversity of Cultural Expressions, the CDCE. As much as possible, we are coordinating our efforts and presenting a united front. We're all in this together. As the campaign evolves, we may also ask you to sign a petition that ACTRA National can send to the government, letting them know Canadian performers support the Online Streaming Act. We'd like to make the message clear that our membership and industry supports this legislation. We also ask you to please keep an eye out on your email. We'll be sharing important information about our campaign through our member e-blasts. And we'll be sharing posts on social media. So if you don't already follow us on Instagram, Twitter, and Facebook, please do. Our handle is @ACTRA_National. Again, it's @ACTRA_National. Help us amplify our message by liking and sharing our posts with your networks. Amy and Raj have already spoken on how Bill C-11 will strengthen Canadian creation, writing, directing, production, and performance, increasing opportunities for all Canadians in our industry. The changes proposed in the legislation will allow the CRTC to regulate online undertakings and ensure they contribute to Canadian content production. It's also important for you to know that ACTRA National has been meeting with the MPs sitting on the Canadian Heritage Committee, the people who will be studying Bill C-11 and suggesting amendments. We are meeting with them one-on-one and explaining our position. They need to hear directly from the people who will be affected by the Online Streaming Act, and that's us. All right, so far so good. We're now at the question period. We've given you a lot of information here, so now we are going to go to the submitted questions, and we'll get through as many questions as we possibly can for the second half of this town hall. All right. So the first question is, what is the threshold to determine if media generates revenue? Amy or Raj?
Sure, I'd be happy to take that. This question of like thresholds for generating revenue is really only relevant in the social media space. So this is not something that we would be addressing on a platform like Netflix or Disney or anything like that. So we're really talking about user uploaded content on social media, and the way the bill is structured is that it asks the CRTC to consider certain factors in determining whether some certain user uploaded content should be within the scope of the legislation. And one of those factors is the extent to which it generates revenue. So it's clear that if it does not generate any revenue for the copyright holder or the uploader, that it would not be within the scope of the legislation. After that, it will be for the CRTC to determine what the appropriate threshold, so what the appropriate extent is. And that's not included in the bill. It will be something for the CRTC to determine as they come up with their regulations after, of course, a consultation process that they're required to conduct.
Great, thank you, Amy. Our second question, how will this ensure opportunities for up and coming Canadian talent? What are the rules for hiring talent within this bill? As it is, most American productions have to hire very few Canadian actors and fly in American actors for small actor parts. How is this going to protect our industry and ensure producers have to hire Canadians and don't use loopholes? Will this help Canada establish a star system? There's a lot in that question. Raj?
I'm happy to jump in on that. So the most basic answer to that is this is about instituting Canadian programming obligations on the streamers. And when I say Canadian programming obligations, there's an entire set of rules around what is defined as a Canadian program. There's a point system in place, and essentially that means that there's Canadians in lead roles, Canadians predominant in programming, and Canadians behind the camera as well itself. So when we put these Canadian programming obligations on the foreign streamers and they're making this content, it will be predominantly Canadians in front of and behind the camera. So that's opportunities for Canadians both in front of and behind the camera. That's the first part of my answer. The second part of your question about emerging talent is a great question. The CRTC has traditionally had a number of policies with respect to emerging artists, both in the radio space as well as the television space. And it's never really instituted hard requirements, but this bill could be a great opportunity to engage in a new discussion around a new framework with respect to emerging talent that would be applicable to online undertakings. So I would certainly encourage everyone to stay plugged in with respect to those CRTC policy proceedings, offer your opinion about the need for an emerging talent policy, and encourage the CRTC to create such a policy that would be applicable not only to the online undertakings, but potentially also the traditional undertakings, so that new and emerging talent can have a space in the system.
Great. And just to reiterate that this supports Canadian content, Canadian creation. And the question was more leaning towards bringing American production in. That's a different thing as a service industry. What Bill C11 would provide us with the opportunity to create our own content and our own work here. So yes, there would be more opportunity. The third question, could Bill C11 restrict freedom of expression? This was a concern last time. So this is a big question. This is a question that comes up very often. Raj, you want to, or Amy?
Absolutely, I'm happy to answer it. I'm sure Amy has her opinions too. The answer is absolutely not. The entire freedom of expression question is a bit of a red herring. There is nothing in this act that touches upon freedom of expression. As Amy has said, and as ACTRA will happily reiterate and certainly oppose in any respect, no part of this bill will apply to individual Canadians. Ordinary Canadians will not be captured by this act. Nothing you do online will fall under this act. And you should share that far and wide so people understand. There's this notion that the ordinary average Canadian is going to be captured by this legislation. It is completely 100% false. There are no freedom of expression concerns. So I will happily put that concern to rest.
Raj, you gave examples before in the past, like people's cat videos or whatever, just so people have a really clear understanding? Could you give a couple of examples of the comparison so that people understand the freedom of expression, how it won't affect that?
Sure. I mean, so think about any platform on which you operate. I mean, the most popular example is someone uploading, a video of their cat or their grandchild onto YouTube. You are welcome to do that today, and you wouldn't be captured by regulation. And you are welcome to do that after the Online Streaming Act passes, and you will not be captured by regulation. Now, there are some ongoing discussions, as Amy alluded to, about whether or not the CRTC will use its authority under this act to potentially create a framework to capture commercial entities. So these are entities who are using these platforms to essentially operate a commercial business. But that's a potential framework. There's no obligation to necessarily go in that direction. And even if the CRTC were to create a policy around that potential activity, none of that would apply to an ordinary Canadian uploading videos of, their weekend out of town or their grandchild, celebrating a birthday party. So, it really comes down to whether or not the activity is commercial in nature or not. I want to be absolutely clear. The things you do on social media on a day-to-day basis in terms of interacting with your family or friends will never be captured by this act in any capacity.
Yeah, I mean, if I could add just one thing, I think that's a very thorough answer, is that the obligations that this legislation creates are obligations on platforms, right? So it's an obligation that YouTube might face, or that TikTok, let's say, YouTube might face. It's not obligations that could be placed on the users. So even commercial users, YouTube could face some obligations in terms of how much money they need to pay because of the number of commercial users they have or the amount of commercial content they host, but that's still not an obligation on the user. So this is really about placing some kind of some rules and some obligations on the platforms. And the CRTC, of course, this is legislation. It has to be reviewed for compliance with our charter. And the fact that it's being tabled in Parliament is an indication that that type of review has going to occurred very thoroughly, and implications on all the different charter rights have been assessed. And then finally, the CRTC is an entity created by statute, and every time they make a decision, their decision needs to be in compliance with the charter and in compliance with the right to freedom of expression. So when people point to things in the act and say, but if it was used this way, that way, it could interfere with somebody's freedom of expression. Well, that's a consideration the CRTC needs to take on board, and isn't able to, by law, to make decisions that contravene freedom of expression. And if they are, they can be challenged in court. So there's a lot of different safeguards here to make sure that individuals' freedom of expression is protected.
Great, thank you very much. How will Bill C-11 help out revenue generating content creators on platforms like Twitch?
So I would start by saying it may or may not, right? So it depends on the type of content and what's happening, and specifically what's happening on Twitch, and so it really comes down to is the type of content being created the kind of content that we might consider Canadian programming, and if it is, there may be eligibility for support, but for the most part, if it's not, then there may not be, at least initially, any kind of direct revenue, for example, between, again, depends on the type of content, but if we're talking about like streaming gaming videos or things like that, that for the most part wouldn't be impacted by this legislation.
Okay, thank you. What happens if the streamers just say no to paying? Can the CRTC effectively turn them off?
I'll jump in. The answer is no. The CRTC will get new abilities under this act to administer what are called administrative monetary penalties. So there will be no ability to just shut off a website. That's a power that's never been granted to the CRTC with respect to applications of this nature. But if the CRTC issues an order applicable to a platform, the platform chooses not to abide by that order, the CRTC will have tools in its toolbox to take that application to task. Generally speaking, they'll have the ability to call them to the carpet using a mandatory order, and in the most extreme examples, they'll be able to issue an administrative monetary penalty. And generally speaking, when you force someone to pay for doing and not doing something, they sit up and pay attention. So it wouldn't be a situation of censorship in any respect. That's not a tool that is going to be given to the CRTC, but they will have the ability to issue penalties, and that usually makes people sit up and pay attention.
Okay, great. Censorship, that dirty word. Okay. Would it be fair to say that Bill C-11 in subsection 7.7 gives the federal government the right to define and change at any time orders to the CRTC about such issues as time allotted to Canadian programs by broadcasters and broadcasters' expenditures on developing Canadian programs? So would Bill C-11 shift final authority for regulation from an independent authority, CRTC, to politicians in cabinet?
So I'll take a first crack at that, and I would say no. If you look at Section 7, there was some changes around some of the procedures related to issuing of policy directions, but there was no change to the substance of what a policy direction could cover, and those are broad matters of policy and not kind of specific orders or regulations or items under it. So that general authority to provide direction on broad matters of policy has not changed under Bill C-11. So there's no change, no change in terms of the balance between the government and the independent regulator. And if Raj wants to add something to that, he's welcome.
No, I think you nailed everything you needed to say there, Amy. My reading, I'd have to go back and look at Section 7, but from my initial reading, nothing jumped out as being an overly prescriptive change that would cause any disquiet or concern.
Won't the clause that prevents the CRTC from intervening in source code or algorithm make it impossible for them to require, for example, that 30% of all programs offered to consumers' music be Canadian, or to require them to highlight Canadian music as consumers are searching?
I mean, I can start by saying that it would not. So the CRTC can still do outcomes-focused regulation. So they could require a certain outcome, like the one that you just gave as an example. What they couldn't do is provide a specific source code or say a specific algorithm to tell the platform or tell the service how they achieve that outcome. But there's no interference with their ability to impose an outcome. One important thing to think about when looking at a bill like this is that all the sections need to be read together. So you need to read the section about algorithms with the actual fact that they have a power to make orders about presentation of programming, so showcasing and discoverability.
Yeah, absolutely. So we've taken a hard look at that section too, and that's certainly something we'd like to discuss with the committee if and when they begin their review. But generally speaking, we interpret that section in a manner similar to how Amy described it. So when we read that section, it basically says the CRTC has the ability to issue an order saying, for example, YouTube, you will do X. It doesn't have the ability to say, YouTube, you will do X in this way. So YouTube is still the flexibility to do it, however it is necessary to do it under its operating algorithms and its source code. But the CRTC can still require them to do that. It's just up to YouTube as to how they do that. So the CRTC can't mandate a specific way of doing it. So we're still confident from an early reading of the Act that the CRTC doesn't have the ability to dictate specific source code or algorithms, but retains the ability to direct general action and activity.
Okay, great. Okay, so how would this act help create more jobs for performers, Raj?
Well, I mentioned this in my presentation, and I think I answered that in the first question, but happy to go back to it. This legislation is all about instituting Canadian programming obligations on streamers. So perhaps if I give an example, Netflix is a great example. So Netflix has been in Canada since 2010. They're clearly going to be an entity that's likely captured by this legislation. So the bill passes, the CRTC does its policy review, it institutes a framework for entities that resemble Netflix, and they have a programming obligation of, let's say, they have to reinvest $10 million a year to Canadian programming. So what that means is, or probably more than that, I don't know what their annual revenues are. I'm just throwing a number out there at random. But Netflix would either get an obligation to invest in Canadian programming, in which case that money would either go to a fund, or Netflix itself would essentially invest in Canadian programming and then essentially show the CRTC how it spent its money, or it would be given a direction to do a certain amount of Canadian programming in terms of shelf space on its service. And in either case, what would result in is that Netflix would have to demonstrate through annual reporting to the CRTC that they fulfilled that condition, and they'd have to be able to show what that Canadian programming was when it was added to their service. And they would have to show in terms of that new programming how it meets the Canadian programming requirements. So how many Canadian performers were on each show, how many Canadian directors, how many Canadian writers, things of that nature. So in terms of holding these streamers to their feet to the fire a little bit, there are likely going to be reporting requirements that are likely done by the CRTC on an annual basis. Those annual reports will likely be made public. And so not only will the CRTC, but the public will have an ability to see on an annual basis how these applications are fulfilling their Canadian programming requirements. And then we can all judge for ourselves if they've done it successfully.
And again, there's a sort of related question on this. When you say opportunities for Canadians, do you mean Cronenberg and Sarah Polley who don't need the help, or will this help foster new talent? It should foster new talent because creating more content, more opportunity fosters new talent, right? So
yeah, absolutely. I mean, so I would agree with that absolutely, Eleanor. We're talking about a significant influx of Canadian programming obligations into the system in terms of expenditures and actual content creation. And I mean, I can't tell these entities how to do their job, but I have to imagine there is so much fabulous Canadian talent out there that if the rational entity would want to leverage that amazing talent, both in front of the camera in terms of Canadian performing talent, but also behind the camera as well in terms of directors and writers. I imagine they would want to use as many Canadians as possible to get a feel for the talent level in terms of what this country has to offer, and to build those meaningful relationships. I personally believe that when these streamers begin investing meaningfully in Canadian talent, they're really going to see the depth of talent we have in this country, and it's going to cause a flowering of sort of a golden era of new Canadian content to flourish on these platforms. I'm an optimist though, but I genuinely think that could happen, and I really hope it does happen. And I think it represents a huge amount of opportunity for absolutely everybody on this call.
Absolutely. And you've heard me say before that I feel that it's Canada's time. We need to take our spot on the global stage and have our stories heard around the world. And this is our opportunity. And that's why, for all of you listening here today, it's so important for you to be engaged in helping us push through this legislation, because this is about our livelihood and our industry and our Canadian content that we need to get out there to open up these job opportunities and to foster new talent. Here's another question. Will there be any impacts on the Copyright Act?
So I'm going to defer to Amy a little bit too. So the answer is no. The copyright regimes and copyright reform are dealt with under the Copyright Act, and there's been no public indications at this point that the government is looking to review the Copyright Act, although certainly that would be a discussion that ACTRA would be interested in. Wink, wink, nudge, nudge, Amy, if you want to pass that along to your superiors. But no, there would be no effect on copyrights under broadcasting reform legislation.
Yeah, so I can confirm that there's no policy change with respect to copyright that's undertaken within that, with like to the substance of copyright. If you look if you dig deep in the bill, you'll see some consequential amendments, but they're really just to maintain the system as it is. So there's small changes made to the Copyright Act to make sure that there's no inconsistencies between the two legislation, because there is a few crosswalks where one refers to the other, but there's no change in the policy. So you won't notice any change to the copyright regime. And very happy to talk with you, Raj, about changes to the Copyright Act whenever you're available.
All right, another question. Can you say more about money going to a fund? If money goes to a fund, how will that fund be accessed by Canadian Productions specifically?
So that's a great question. And you know, Amy, I invite your perspective on this too. So it remains to be seen exactly how that procedure is going to lay out. So right now, there is a process in the traditional system. So cable and satellite companies on an annual basis are required to invest up to 5% of their annual revenues to a Canadian fund. Typically, that's the Canada Media Fund. The Canada Media Fund takes that funding, and it has an envelope of funding of which is approximately 2/3 from the cable and satellite companies and 1/3 from the government of Canada, and has a big pile of money. And the Canada Media Fund distributes that funding to producers who have worked out licensing deals with broadcasters. And then the producers make their show on behalf of these broadcasters. The show is broadcast, and it sort of creates this virtuous circle of programming that continues on to the following year. So that's one example of how production funds work today. I'm not a CMF expert, but at a high level, that's how the production fund works. But the CMF isn't the only fund out there. There's the Independent Production Fund. There's the Radio Star Maker Fund. There was the Harold Greenberg Fund. I don't know if it's still going on, but there's a bunch of funds out there. Whether or not the CRTC requires, so the first question for the CRTC will be which streamers are required to actually commission programming to be aired, and which streamers will be required to make a financial contribution, and which of them will be required to do both. And once it has that conversation, it determines which streamer will be doing what. For those that are required to make a financial contribution, the CRTC will need to determine, okay, to whom do they need to make this financial contribution? Is it the Canada Media Fund? Is it another pre-existing fund? Perhaps the entity comes forward and says, you know what, these funds are great, they do a great job, but we think we need to have our own fund that's specific to content that is aired on online undertakings. So perhaps they either create a new fund, or they partner up with other online undertakings to create a special new fund that specifically funds Canadian programming on online undertakings. It could happen. I don't know. I mean, I'm sure these are discussions that are happening. So that would be the second choice for the CRTC. Where is that funding dedicated to? And then, of course, once that decision's been made and the funding starts to go to that fund, whatever that fund may be, there will be reporting obligations. And so the fund will probably issue an annual report. The fund will have independent governance. Most funds do. So they'll have their own board of directors. They'll have their own staff. They'll have an annual report that they'll issue to disclose to the public. This is public money after all. It's being reallocated by direction of the government. So this entity, this fund, will have to publicly report with respect to how this fund and how this money has been dispersed, and to whom that money was given. And then, certainly these entities, the entities themselves, the online undertakings, will have to report to the CRTC as well. So you'll have a dual reporting structure: the fund reporting itself and the entity reporting to the CRTC, and you'll be able to cross-reference that funding to see where the money went, how it was spent, and decide for yourself if it was an efficient use of the dollars.
Great. Amy, did you have anything to add to that, or?
No, actually, I don't. I think, as Raj indicated, there's still some uncertainty in the sense that the CRTC, we know, will be directing money to funds, but which funds, exactly how that's going to work, a lot of that is going to be the result of public processes held by the CRTC.
Great. Do you know if the streamers are engaged in this legislative process, and have they brought it in cooperating with the outcome?
That's a great question. So the answer is yes, they've been very involved. I'm sure, obviously, Amy has had conversations with a lot of people, so I won't ask her to disclose the confidentiality of those conversations. I can tell you that I know a couple of streamers have been very engaged and have quietly circulated some draft language that they would like to see incorporated into the act, which I think is great. I think it's great that the streamers are engaging in the process. They clearly see that the legislation is coming. They want to ensure that the bill has the best language for them as well as for us, and they're engaging in terms of making proposals with respect to revisions in the act. So I've had some high-level conversations with a few of their regulatory representatives. I imagine those conversations will be ongoing for the next couple of months. And I imagine these online undertakings have hired their consultants, and these consultants are reaching out to MPs and the department as well. It's part of the process of making new laws. There's a multitude of interests at play here. The streamers operate in Canada, and as long as they're willing to play ball and become, take their place in the system, we're happy they're here. We're happy they're spending money here. We want them to take their place in terms of being good corporate citizens, in terms of supporting the Canadian ecosystem. If they're willing to do that, and they're happy to do that, then I certainly hope they're engaging. And we would always be happy to have any conversation with them to ensure the best possible system.
Okay, so there's so many questions, but I will just be able to take one final one. So the final question is, how can we help get Bill C-11 passed? Well, I had spoken quite a bit about it, that ACTRA National is building a take action. And so if you go to the website actra.ca, there will be guidance on how to reach out to your MPs, send letters, speak to them, post on social media, things like that, so that we can actually get the message out and show your support behind this legislation, Bill C-11. So keep updated with the emails and everything like that. Raj, Amy, would you like to add anything?
No, I think you got it all. All those options are available to our members. Social media is out there. Write your MPs, pick up the phone and call people if you're so inclined. Engagement is the most important thing.
Yeah, and it's really big. It's really big for our industry. We need to get this going. This is our livelihood. So, all right. Well, that's all the time we have for this virtual town hall. On behalf of ACTRA National, I'd like to thank Amy from Canadian Heritage for joining us today. Thank you so much. And for their continued work on the Online Streaming Act. On behalf of myself and Raj, we'd like to thank all of you for taking the time out of your busy schedules to learn more about this critical piece of legislation. We hope that we answered many of your questions. And one last reminder, repeating, but it's important, please be sure to keep up with the latest news about the Online Streaming Act by visiting actra.ca, as well as following ACTRA National on Facebook, Twitter, and Instagram. Again, our handle is @ACTRA National, easy. So we hope you found today's town hall informative, and we will see you soon. Thanks, everyone. Thanks so much for coming.